outrageous fees that I've seen coming from them.
Just before I call the next member, I'd just like to advise members that electronic devices not used in debate should be placed on the drop-down work surface so that they don't interfere with the Speaker's view of the House. Member on my right.
Charles. Mr. Speaker.
I call the honourable member Charles Chauvel.
Thank you, Mr. Speaker. Mr. Speaker, one of the many problems with that previous contribution is that the Minister, who herself wasn't a terribly successful lawyer in practice, now seeks to educate the House about access to justice. She, who is dismantling the legal aid system and making harder for families to get access to the family court, has the temerity to come into this House and talk about trying to make access to justice easier for New Zealanders. Well, I say to you, Mrs. Collins, your true colours are on display today, well and truly, metaphorically as well as figuratively. So the reality of what the Minister says can be deconstructed very easily in this way, and that is to somehow pretend that restoring the title of Queen's Counsel to practitioners in New Zealand will make lawyers cheaper to access because they won't just have to go to big firms is patently ridiculous. The ability to charge for legal services at the bar when one has the title Queen's Counsel is absolutely superlative. It won't make 1 cent of saving to any consumer of legal services in New Zealand to see the title QC restored, and we should be very clear about that right up front, sir. And sir, while I'm on this point, I think it's interesting that we have the legislative history of this bill before us. For the last 4 years, the government could have, at any stage, made appointments to senior rank in New Zealand for our legal profession. Under the existing legislation, the Lawyers and Conveyancers Act, there were very clear guidelines in place that lawyers could follow to apply to be appointed senior counsel. And in order to do that, the Attorney-General would have to agree to hold an appointments round. Well, for the last 4 years, the Attorney-General in that national government has refused to do exactly that, sir. And guess who has suffered as a result of that? Not the government, but actually the New Zealand legal profession. Because every year that Chris Finlayson has spitefully refused to hold an appointments round, just because he doesn't like the name that the previous Labour government attached to our most senior lawyers, senior counsel rather than Queen's Counsel, our legal profession has missed out. They are the ones who've suffered. Because Australian lawyers, every Australian state and territory for the last 4 years has held a senior counsel appointment round. And those Australian lawyers are eligible to be admitted in New Zealand and to practice in our courts. We've seen the Canterbury earthquakes occur over that time. Well, sir, it's those senior counsel from Australia whom the big insurance companies have been instructing to give the big opinion work. Not our lawyers. They've been missing out because this government has just spitefully and stubbornly refused to hold an appointments round under the existing legislation. That's how much they care about the legal profession and about top-class access to justice in New Zealand. And I hope no listener is fooled by the honey words that we heard from the previous speaker. Sir, there are a couple of major issues with what the Parliament is doing today, and I can't quite hear the Minister for Work and Income, but if that member were honest, she wouldn't have that hair colour, but we won't even go into that. The issue here, sir, is threefold. The issue is threefold, sir. Apart from the matters, I'm only following your lead, Ms Bennett. I'm only following your lead and that of the previous speaker. But the reality is the problem of this legislation is threefold. First of all, it is an archaic title. Every other common law jurisdiction, apart from England, has abolished reference to Queen's Counsel. They've cut the apron strings, they've gone ahead, and they've said, no, we want to call our senior lawyers by an appropriate title that reflects the way in which our modern society functions. Now, it is true, as was mentioned in one of the debates, that the Queensland government is thinking about going back to the title of Queen's Counsel. Well, what a great slogan it would be for this government to say, where Queensland goes, we go. I mean, I'm not quite sure that anybody's going to be inspired by that example. I'm not quite sure why we would take the same leap backwards into the past that the Queensland Conservative government has taken, and I hope that we don't see members opposite following them in other areas of retrograde social policy where they've actually been treading the boards, sir. But, sir, apart from the title of Queen's Counsel, to which we object, there are two other major reasons why this is a bad idea. And they are these. First of all, the move to restrict the appointment of Queen's Counsel just to practitioners in independent barristerial practices is bad because it will shrink the diversity of our senior profession. Now, it's a self-evident fact. Any lawyer will tell you this. If you want to have a career and a life, particularly if you're a woman practitioner, it's much easier to try to do that in a law firm or a government department or local government or a university than it is to go to the bar. And here's why, sir. At the bar, you have to support yourself at all times. You can't pool your risk, you can't join a partnership, you can't be employed by anybody. So if you want to take parental leave or any other sort of leave, you really need to either save to do that until you can afford to go off for, say, parental leave purposes, or you just don't. And that's the reason why, despite the fact we've had so many great female lawyers come out of our law schools over the last 25 years, we still have a senior profession that is basically still male-dominated. And what this move will do is simply consolidate that, because by saying, in order to be recognised as one of our most senior lawyers, i.e. a QC, you have to be only a barrister practising independently, well, essentially what you're saying is the economics are going to be against women in practice. And I just want the women on the government bench to know that, if they haven't worked it out already, because that's what women lawyers all over the profession are saying. The Minister may think she's doing a terribly clever thing here to curry favour with the senior ranks of the bar, but I can tell members opposite that it will be pretty drastic in terms of its consequences for diversity in our legal profession. So the other reason why it's wrong is this. The appointments process that was set out in regulations made under the Lawyers and Conveyancers Act, and which are still in force, for senior counsel was a very open one. And it was well understood. It was set out in a set of regulations and then in guidelines that were published under Regulation 5 of those regulations that were issued by the Solicitor General. And people knew what they had to do in order to be appointed. There wasn't an old boys network running. There wasn't some secret, mysterious process as has occurred in the past. And the great fear must be that with the ending of the title senior counsel, the reversion to QCs, the repeal of the relevant legislation, we will go back to that process shrouded in mystery where essentially it's people well known to the Attorney General and only those people who can really hope to be appointed to that most senior role of Queen's Counsel in our legal profession. And that's the other great shame of this bill, sir. I put a supplementary order paper forward at the committee stage that would have fixed that up. It would have kept the open appointments procedure, but that was voted down by the National Party and its allies. And it's a great shame because that, along with the requirement that lawyers practice not in firms but only at the bar, will again contribute to a great shrinking in diversity at the senior levels of our legal profession. And if anybody thinks that that's a good thing, then I challenge them to get up and explain why. Sir, Part 2 of the legislation does do some worthwhile things, and as we said in the committee stages and in Select Committee, we are supportive of the changes that are made there to the way in which rules relate to incorporations of firms, both of lawyers and of licensed conveyancers, and in terms of the disciplinary procedure, and in terms of having the Dean of the Auckland University of Technology Law School represented on the Council for Legal Education. But because the provisions of Part 1 are so bad, so retrograde, such a backward step, such a reversion to an old, closed regime the way that New Zealand used to do things in the 1950s, the great leap backwards taken by the National Party today, this Labour opposition will not be supporting this bill.
I call the honourable member